Okay, I think we're going to kick off now. So I will start by saying hello and welcome to everyone. My name is Fiona Rutherford. I am the Chief Executive of Justice, and I can speak on behalf of the whole team to say we're really excited today to be hosting this event with Matrix Chambers. It's the first in our planned series on the current conflict in Ukraine, a series that we're describing fairly simply as our Ukraine series. And we're going to do a mixture of virtual and in-person events that will take place across the UK. But before we start the event, there's a small amount of housekeeping to cover. So there's going to be some opportunity at the end of the panel's presentations to ask some questions. So please do submit your questions into the Q&A box. Do specify a speaker's name if the question you'd like to ask a question of a particular panelist. And also to let you know that today's launch event is going to be recorded, but that won't include the question and answer section. And then the recording will, of course, be uploaded onto our website. Now, as some of you aren't members of Justice, I just thought I'd just give a little bit of background about the organisation. So we're an all-party law reform and human rights charity, which has been at the forefront of law reform in the UK since 1957. We aim to promote a fairer, a more accessible justice system for all, and we carry out research and generate practical, workable and evidence-based recommendations for reform. We've got a history of scrutinising and challenging developments within the justice system that threaten the country's adherence to human rights and the rule of law, something that no doubt will be touched upon as part of this event. We're a members organisation. We're open to all, so if you appreciate the quality of the conversation this evening, I'd really urge you to support us perhaps throughout the year by considering to become a member or perhaps making a donation. You can do both via our website, and we'll send you a link after the event as well. We, of course, continue to be incredibly grateful for the commitment and support of the many expert lawyers, judges, academics, parliamentarians, students, and many other professionals and non-legal experts who are already Justice members. So on the subject of experts, I am very pleased to introduce you to our fantastic panel for this evening. We have Dr. Yulia Ioffe, and we have Simon Cox, and we have Sam Knights, Queen's Counsel. I'll just quickly run through, give you a little bit of information about each of our speakers before handing the floor over to Yulia. So Dr. Yulia Ioffe is a lecturer in international human rights and humanitarian law at UCL, the Institute of Risk and Disaster Reduction. She received her doctorate from the University of Oxford, where she focused on the rights of asylum-seeking children, particularly the rights to family life and liberty. Prior to joining academia, Yulia worked at the UNHCR in Ukraine and in Bosnia and in Herzegovina, and Ukraine Red Cross Society. And she also clerked for Judge Crawford at the International Court of Justice. Simon Cox is a barrister and rights activist at Doughty Street Chambers, specialising in migration, equality and EU law. His portfolio is deeply impressive and ranges from Court of Appeal cases such as Essex, HD and Akinsanya to Chowdhury in Greece, which is a European Court of Human Rights case considering forced labour of irregular migrant farm workers through to the UK Supreme Court. He was a migration lawyer at the Open Justice Society initiative between 2011 and 2018, litigating and advising supporting migrant-led groups to use the law and work with lawyers, especially in Southeast Asia and Greece. Sam Knights QC is well known as a versatile and established SILT with a really broad practice focusing on immigration and asylum, public law, human rights, international law, and commercial litigation, and her cases have involved groundbreaking developments in law, as well as complex cases involving trafficking and modern slavery, and test cases on asylum law at the Court of Appeal, the Supreme Court, European Court of Human Rights, and the Court of Justice of the European Union. She's also been involved in national security cases before the Special Immigration Appeals Commission. She's also appealed in a number of high-profile claims arising from the Iraq and Afghanistan conflicts, including cases concerning the protection of individuals fleeing from conflict zones, and liabilities of the British government for locally engaged workers, as well as cases involving national security and terrorism issues. So I hope with all of that information now set out, you will join with me in being incredibly impressed with the quality, the background, the depth of knowledge that our speakers clearly have. But with no further ado, I am going to hand over to Yulia first as our first speaker. Yulia, well, each speaker is going to speak for around 15-20 minutes or so. Then, as I say, there'll be some time for questions and answers at the end. Over to you, Yulia. Thank you very much indeed.
Thank you so much, Fiona, for this kind introduction, and thank you for involving me in this event. It's a great pleasure to be in the panel with such prominent speakers. So I will start with just outlining a humanitarian situation in Ukraine, providing the current numbers of refugees and internally displaced persons, and also I will focus on three main rights that I think are particularly important in the context of the refugee crisis in Ukraine. So at the very start of the armed conflict, the UN Refugee Agency has predicted that there will be around 4 million Ukrainian refugees in total. However, already now we can see that the refugee population from Ukraine is around 5,300,000 people. Although, again, comparing to just last week, there has been 4.8 million refugees from Ukraine. Now, UNHCR projects around 8.3 million refugees from Ukraine. And just to give you a perspective, the population of Ukraine is around 40-45 million people. So it is possible that the number is even higher than that. UNHCR also provides a number of 1,200,000 people of Ukrainians who entered Ukraine since 28th of February. So we see that there are some border crossings, so some people are returning back to Ukraine, but the situation is highly volatile and unpredictable, so it is difficult to say whether this return is permanent. But from anecdotal evidence, it does seem that people are returning to Ukraine, for example, to Kiev, which is now not surrounded by the Russian forces. Although, again, there are still regular bombings of Kiev and other cities, including the relatively safe cities in the west of Ukraine. An additional 7.7 million people are internally displaced, which means that, again, if we count refugees and internally displaced persons, more than a quarter of Ukrainian population has been forced to flee since 24th of February. According to the UN Children's Agency, almost 2/3 of Ukraine's 7.5 million children had been displaced as a result of the attack by Russian forces, which means that 2.8 million children are internally displaced and 2 million have fled Ukraine as refugees. I think we will be talking about the fact that, unfortunately, Ukrainian refugee crisis is not unique, but I also think that we can agree that the number of refugees in such a short amount of time is unprecedented. A lot of humanitarians and UN officials also note that the level of destruction of civilian objects in Ukraine is unprecedented. Ukrainian cities are being completely destroyed. Russian armed forces target all infrastructure necessary for survival of Ukrainians, including healthcare facilities, water infrastructure, power plants, bridges. There is also a terrible destruction of economy as Russian forces target mines, plants, industrial objects. And of course, saving lives is the most important thing, but we should also think about what would happen to Ukrainian refugees when the hostilities end. How can Ukrainians go back after this war? I would also want to highlight the particular demographics of the Ukrainian refugee population. So Ukrainian men, as many know, from 18 to 60 years old are unable to cross the border because of overall mobilization. So 90% of Ukrainian refugees are women and children. Among them, there is also a rising number of unaccompanied children, as some parents decided to stay back home to help with the military efforts. in Ukraine, or because they were caring for a relative. And of course, Ukraine has also been advocating orphanages. In this presentation, I will focus mostly on Ukrainian refugees, but we all know that similar concerns are also applicable to internally displaced persons. I would like to focus on 3 rights under international law that I think are particularly important in this context. These are the right to family reunification, the right to health, and the right to education. These are also the rights compliance with which involves significant financial resources and a heavy reliance on reception systems of the countries of asylum, especially in the situation, if the situation becomes protracted. The neighboring countries, in particularly Poland, have taken the majority of Ukrainian refugees. I think now the number is around 3 million people. And although according to the EU Temporary Protective Directive, Ukrainian refugees do not have to stay in the first country they entered, it seems that many Ukrainians are still trying to stay near the border. So again, many refugees are staying in Poland. The resources of the receiving countries have been already strained. These countries will need increased support, including financial support from other countries and the international community as a whole. The Ukrainian refugee crisis will definitely test political solidarity. As I just mentioned, Ukrainian refugees are mostly women and children. The armed conflict has broken down many families and created a lot of family separation. Ukrainian refugees have left behind spouses, fathers, brothers, uncles, and grandfathers. When people flee conflict, the separation of families can have devastating consequences on family members' well-being and the ability to rebuild their lives. The separation of a child, in particular from his or her family, can have debilitating effects on child's physical and mental health. The EU temporary protection framework, for example, includes family reunification provisions, but they're quite limited. And there is, of course, a question: what happens to Ukrainian refugees when the protection is over in 3 years? Unfortunately, and again, we are talking about the right to family life under international law. Unfortunately, the convention relating to the status of refugees does not contain a specific provision related to family life or family unity. In fact, the term family is not even mentioned in the Refugee Convention, but only referred to indirectly once in Article 12. Under international human rights law, the right to family life is not guaranteed in absolute terms. For example, Article 17 of the International Covenant on Civil and Political Rights, as well as Article 8 of the European Convention on Human Rights, safeguard the right not to be subject to arbitrary or unlawful interference with family life. Most international human rights treaties, however, do not expressly establish the right to family reunification. It is rather thought to derive from the right to respect for family life. And the majority academic opinion is that the right to family life under international law does not provide a refugee with a right to family reunification. A possible exception to this framework is the Convention on the Rights of the Child, which contains a unique provision, Article 9, establishing, in my opinion, a right to family reunification for all children, including children seeking refugee status and Ukrainian refugee children in this context. Article 9 of the Convention on the Rights of the Child is, in near absolute terms, provides that states shall ensure that a child shall not be separated from his or her parents against their will, except when such separation is necessary for the best interest of the child. Unfortunately, as you can see from this quote, if the right to family reunification indeed exists, it only extends to children, that is, individuals under 18 years old and their parents, which is very limiting definition of family. I know that other speakers will also touch upon this topic, what is the definition of family and how restrictive it should be. However, there is an academic, going back to the discussion of Article 9, there is an academic discussion on whether this article applies only to domestic situation in which parents and children are separated. I argue that Article 9 of the Convention applies to refugee children as well, and I talk about this more in a forthcoming article, but definitely this topic warrants further research. Regarding the right to health, which is established by Article 12 of International Covenant on Economic and Social and Cultural Rights and Article 24 of the Convention on the Rights of the Child. It includes the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. And to fulfill these obligations, the consequences of war, trauma, and devastation must be tackled swiftly. The subsequent midterm and long-term needs must propel healthcare sector into rapid action. Ukrainian refugees now have received welfare rights, including the right to healthcare similar to the EU citizens. And again, this is applicable to the treatment in the EU countries. However, it is important that the implementation of these rules and policies is assured without restriction. As the crisis in Ukraine becomes protracted, access to healthcare could be at further risk because nations have varying levels of preparedness and reception and variable health systems, which will be strained by the large number of people arriving from Ukraine. I would also like to highlight that immediate attention must be paid to mental health and psychological health, especially for children, including the victims of sexual and gender-based violence. There have been reports of high level of rapes, gang rapes, rape of children, rape of parents in front of children, and generally enhanced cruelty by the Russian armed forces, which target the visible and invisible bonds that make community life possible. These sorts of ritualized rapes and rape murders are common atrocities during genocide, and these issues should be discussed and researched separately in the context of prevention of genocide and punishing its perpetrators. And finally, the right to education, which is included in Article 28 of the Convention on the Rights of the Child and Article 13 of the International Covenant on Economic and Social Rights. It provides for the right for everyone to education that is directed to the full development of their human personality. And similarly to the right to health, it seems that at least in the EU countries, Ukrainian refugees have access to education, but again, the problems may arise with the implementation. For example, Polish schools are already experiencing some difficulties with an influx of Ukrainian children. And I would like to conclude my presentation with 2 points. First point is that the Ukrainian Ombudswoman of Human Rights, she reported that 600,000 people, including around 120,000 children, were deported forcibly to Russian Federation. And Russia is reportedly working on legislation to fast-track the adoption of these children. If this information is correct, these actions violate a number of international laws. But since it is difficult for Ukraine to get access to the citizens that are now in the territory of Russia, cooperation is urgently needed from other countries and international community as a whole. And my second and final point is that in the UK and also in the Western media and among Western politicians, there has been the language of generosity to Ukrainian refugees. And a lot of media and newspapers have used photos of small children and crying mothers to reiterate the sentiment that Ukrainian refugees deserve protection. And of course, again, this is not unique to the Ukrainian refugee crisis. Similar things happened with Syria and Afghanistan and other countries. But we all should remember that while seemingly innocent, this language frames obligations and rights under international law as charity, promoting the idea that refugees, that these refugees are deserving of protection while others might not be deserving protection. Thank you.
Thank you very much indeed, Yulia. As I said at the start, we'll leave questions to the end. For those of you listening in, no doubt intently, please don't hesitate to use the Q&A box at the bottom of your screen if you'd like to ask a question of Yulia or indeed any of the other speakers. Simon, I can see you've turned your camera on. Over to you.
Thank you very much, Fiona. So I've been asked to talk about the Ukraine Advice Project, which I'm involved in, and some of the perspectives and information that we've gathered there. So the Ukraine Advice Project was set up on the weekend after the Russian invasion of Ukraine by a group of friends who are involved with the law, one journalist, two solicitors and three barristers. And what we thought would be useful would be a very quick and easy way to try to connect people needing legal advice with qualified lawyers who were willing to act for free. And the Ukraine Advice Project, which is now powered by DLA Piper, does that. And so people who need help email the project, and the project makes a quick evaluation of that email. Now with DLA Piper sometimes tries to deal with it internally, or sometimes bounces the email on to a solicitor or a barrister who is willing to take that person on as their own client, pro bono, simply for the purposes of advising for that to that query, or perhaps for doing more work. And within a few days, we had hundreds of people contacting us for advice and hundreds of people volunteering, hundreds of qualified lawyers in England and Wales and Scotland volunteering to help us with advice. And I think what we were able to do was tap into what many of us felt was an urge to help. And I think people obviously help best when they help with the special skills that they have, whatever those special skills or attributes happen to be. The problems that we've seen our clients facing, I think, first of all, came from the fact that despite decades of wars in the world, of refugee-producing situations, that the United Kingdom, one of the richest countries in the world, one of the countries with the most elaborate forms of rule of law, of mechanisms, of bureaucracy, of legal systems, that the systems we have in place to help refugees and their families are so restricted that politicians immediately recognize that they would not be acceptable to the public as answers to this crisis. So our regular rules would have seen us trying to stop Ukrainians getting on planes no matter what, would have seen Ukrainians and British people here with family in Ukraine unable to be joined by them unless they were spouses, minor children, or in some circumstances, elderly relatives. And I think the Home Office recognised that the public wouldn't understand this extraordinarily narrow and dry definition of family. So the first thing that the Home Office did was recognise that they needed to have a much broader definition of family, and they established what has become the Ukraine Family Scheme. Again, though, initially the scheme was nothing like as generous as it is now, and at all policy levels we have seen politicians and senior Home Office officials essentially falling backwards into more and more liberal and humane positions under pressure from the public, from journalists, and from their own backbenchers. We've seen Conservative MPs volunteering to drive vans out to Ukraine and bring people back, even before that was legal. So one of the key problems that Ukrainians and their family have seen is that the rules keep changing. And in many respects, they've changed for the better, as far as our clients are concerned, but it's meant that there's been a great deal of uncertainty. And so for a lot of the time that we faced, and it's still a problem, people are making applications that can't quite be dealt with yet because the rules haven't quite come into force, or the simplifications haven't yet been brought in. But the Home Office has responded often. I think the staff of the Home Office, once given approval by ministers, have responded extremely quickly to try and make those changes, and have tried to keep up with what actually is also a really under-resourced department. But that's been the main problem, that we haven't been able to give clear advice to people from a legal point of view. And so instead, what we've often found ourselves doing is trying to think more politically with a small p, policy-wise, and to guess where the ministers and the civil servants will be in a week or two, in order that we can advise our clients. So a lot of my clients applied for something that hadn't been invented yet, on the basis that we thought it was about to be invented, and by golly, it was. And so clients were applying for things, and then a week later they were being given them having come into the policy or the rules in the meantime. But it's still moving. So it's not until the 3rd of May that the scheme for extending visas for Ukrainians in the UK to match those being given to Ukrainians coming from outside the UK will come into force. So I have clients who can't apply yet, who are here, who will benefit, but can't apply. And in some ways, that particular thing is a sensible measure, because we want the Home Office to be in a position to respond once the applications are made. It's no good announcing something if you haven't got resources in place. So that's welcome, but it's meant that it's been very confusing for us and our clients. We now have 3 schemes in place. We have the Ukraine Family Scheme, which allows for a very broad family-friendly definition of what family is, to come and join people in the UK who are settled here, British citizens or indefinite leave to remain. And that's one of the key gaps. I'll come back to it. The second is the Ukraine Extension Scheme, which means that people who were in the UK with leave to remain, which expired after the 1st of January this year, and again, that's another gap, can apply to have their leave extended. And the third scheme is the Homes for Ukraine scheme, the sponsorship scheme, in which British citizens and settled people can invite Ukrainians who they don't know, or who they may know, but who aren't their family, to come and live with them temporarily in the UK. And in all 3 of these situations, the government policy is to grant leave to remain, grant immigration permission that will last for 3 years, with no restrictions on employment and no restrictions on claiming social security benefits. So Ukrainians in this position are immediately put into the same legal rights situation, broadly speaking, as refugees would be. But what's striking, and you may have noticed this, is that the government never talks about Ukrainian refugees coming, being granted refugee status. They're not being recognized as refugees, and appears anyway very anxious to keep arriving Ukrainians and Ukrainians already here out of the asylum system, which at the moment is extremely under-resourced, with asylum applicants facing delays of about 6 months in getting their claim registered, if they do it without going in person to the office and queuing up and insisting that their claim is registered immediately. Again, from my own point of view as an immigration lawyer, essentially because of overcomplication and under-resourcing. But that means that as lawyers, we're dealing with a completely new parallel system of rules applying to Ukrainians. Some of I've talked about 2 gaps. The first gap is that Ukrainians who are here legally can't support family members to come under the family scheme or under the Homes for Ukraine scheme, unless they have permanent residence in the UK or they're members of the family of a European Union citizen. So someone who's here on a work permit with 5 years leave doesn't qualify to bring their family here onto the Ukraine Family Scheme. I haven't seen, others may have seen, I haven't seen any real policy rationale from that distinction. The second gap is that people whose visa expired before the 1st of January, they may have claimed asylum before the 1st of January, they may have done other things before the 1st of January, but they're still here, don't qualify under the scheme for extending their own leave. Again, the 1st of January, it's a convenient date, it's computer friendly, but the policy rationale so far is at least escaping me personally. And I should add that the policy comments I'm making here are on my own behalf, not on behalf of the Ukraine Advice Project, which is, of course, resolutely neutral. In terms of the practical issues that people are facing now, we seem to have resolved to a great extent the biometrics problem for people who have biometric passports. Initially, the government was very resolute. They weren't going to let people come unless they had gone to a visa application centre, despite the fact they'd invented a brilliant system for European Union citizens that meant 5 million people got leave to remain in the UK without going anywhere near a visa application centre, simply by showing their biometric passport that already had their biometrics face in it. The government relented, no doubt to the delight of Home Office staffers, who I think were probably quite interested in rolling this out for Ukrainians. So now people with biometric passports can apply online. They then get a permission to come that is electronically connected to their passport, just refers to their passport number, and then they can use that at the airport, though there have been practical problems with some airlines initially not recognizing that. That seems to have calmed down. For people who don't have biometrics, there still is a problem with them needing to attend visa application centres. One second practical problem that we are seeing reports of is that the Home Office is granting visas very quickly to people, to adults, but not very quickly to children, meaning that family groups that include a child are then unable to travel. And there are statistics retweeted on our Twitter account, the Ukraine Advice Project Twitter account, which bear that out, which show a striking difference between the number of people who have had visas issued and those who have arrived. So as of the 20th of April, something like 110,000 applications, 71,000 visas issued, but only 21,000 people arriving. I don't know the explanation for that. One possible explanation is this delay relating to children, which I'm sure is connected to safeguarding, a very legitimate interest, but ultimately connected to a lack of resources, I think, in terms of safeguarding. The other practical problems that we're concerned about seeing people when they arrive, and which are beginning to trickle through, are people arriving in places where their expectations, mutual expectations of the home sponsor and the person who is arriving are very different. We are concerned about the level of resources that local authorities who are in the front line are being given to support people who may not speak English, may know nobody here, and may, in some fraction of cases, but nevertheless it will amount to a significant number of individuals in total, fall out with, or just have a difference of opinion with the people who they're expected or were anticipated to stay with. And I think one of the practical problems here, which is why it's good to see the Department for Levelling Up involved, is that the Home Office is essentially a department that only functions at the border and beyond. It doesn't really function inside the UK. And it's essentially a policing department whose experience is in placing restrictions on what people can do and then taking them away. It's not a social work department. It's not a department that integrates or assimilates people into the United Kingdom. It's not a department that has staff who are charged with that responsibility. And therefore it's not really a department that's in a position to provide, if you like, aftercare of people who've arrived in the United Kingdom once they walk through once they walk away from the airport or the port of entry. It's not a criticism of the Home Office, it's just a function of how they work. So where are we now with the Ukraine Advice Project? Well, we have a total of 526 immigration lawyers on our books and 361 other lawyers. We are still open to more volunteers. You only have to take one case, that's fine. Even one person helped is great. Do feel that you can come along and join us. Our details are on the internet. We are on Twitter as the @Ukraine_advice, and we're on the internet as the Ukraine Advice Project. And so far we have responded to 1,785 queries, individual queries, and we currently have 465 queries in progress. I hope that's a helpful snapshot and review of where we've been for the last 7 weeks as lawyers in the UK. Fiona.
Thank you so much, Simon. And just to ask an immediate question, what are qualifications are required? Just as you've made that plea for any lawyers that are listening, what qualification? Immigration specialist area.
You need to be a qualified solicitor in the United Kingdom and have insurance, because the person who you're advising will be your client.
Thank you very much indeed, Simon. As before, please do place any questions you have for our speakers in the box that's entitled at the bottom that's called Q&A, but I will hand swiftly over to Sam. Thank you very much.
Thank you very much. It's great to be here, and it's really wonderful that that you're doing this series of seminars. And I wanted to start actually by saying how incredibly helpful the Ukraine Advice Project has been. I mean, it fills in a gap because there is no way otherwise that people applying for this visa would qualify for legal aid. So, so that this pro bono advice scheme that Simon helped set up is absolutely invaluable. I'm based down in Devon, and I've been working with various Devon groups who are really keen to welcome people under the mainly under the homes scheme. And so it's been really interesting seeing the practical effects and problems that people are having, actually just navigating the system, finding people, and then, you know, there are so many more people who actually want to help and want to open their homes than have been able to find, and, you know, people, Ukrainians to match with. So there's, you know, it's a very sort of, it's a very ad hoc scheme, which is, I would say, the sort of antithesis really of refugee protection. And I wanted to sort of focus on two things. One is to sort of look a little bit more broadly at how these ad hoc visa schemes fit in with refugee protection, but also look at the Nationality and Borders Bill and what that would mean if it's enacted for Ukrainians, for example, claiming asylum. So just to set these visa schemes into context, and the Ukrainian scheme isn't the only scheme of its type, they're very different to refugee schemes. So the 1951 Refugee Convention, the 1967 Protocol, which are both ratified and domesticated in the UK, don't seek to categorize refugees according to nationality, and they also assume a territorial asylum claim, i.e. that the claim will be processed and considered where it's made. These schemes, these visa schemes, of course, are very specific for different nationalities, and I'll come on to talk about some of the other schemes. The other thing is that, you know, refugees need to move quickly, and they need to be able to access safe havens quickly. They need to do that if they're fearing persecution because they form part of a particular group, or they're being targeted by individuals or by the government, and they also obviously need to do that in the situation of a war. The visa schemes are not always quick, and they are very bureaucratic. They don't work if you don't have access to documentation. You haven't got access necessarily to a phone or computer. You might not be literate. You know, you need, you know, these things, or need to be able to access these things in order to be able to apply for visas. And the basic point is that refugees shouldn't need visas. The reason why they do in the UK context is because of our hostile environment. And those of us who work in this area, unfortunately, are all too familiar with the hostile environment and its sort of ever creeping presence. But if you aren't an immigration lawyer, then I think it is worth just saying something about this, because the hostile environment is not new at all. It's got a very long history involving both Labour and Conservative governments, placing ever increasing restrictions on individuals who were previously able to travel to the UK. And its history is bound up with the history of empire, colonialism. And what we saw from the 1960s onwards, beginning with two Commonwealth Immigration Acts passed in 62 and 68, that the UK started shutting its doors both to British, those who have British citizenship, by separating out British nationality into different types, some which had the right of abode and some which didn't. And at the same time, there was beginning, particularly in the 70s and onwards, a control on immigration. So it made it harder and harder for anybody without a visa to reach the UK. And ultimately, it's led to a situation where it is legally impossible for refugees to get to the UK. So they have to use traffickers, people smugglers, and other clandestine means to get to the UK for safety. And those kind of controls, Simon spoke about border controls, airlines, which are fined if they carry people who don't have visas, so that you can't get on a flight, you can't board a ship unless you can show you've got a visa for the UK. And then in 2012, there was a further wave of hostility. So it was made a criminal offence for landlords to rent for employers to employ somebody who didn't have the right form of status. And there were all sorts of other restrictions preventing undocumented migrants, for example, from accessing the NHS. So we have a situation which is effectively a completely hostile environment for somebody trying to get to the UK to claim asylum, and for somebody who is here without documentation. And if you want a really good and accessible account of this, then I'd highly recommend reading Maya Goodfellow's book called Hostile Environment. So in this context, in order to get round this, to deal with conflict situations, which, as Simon said, the public and people would find unacceptable that the UK wasn't assisting, these ad hoc schemes were created. So we had a Syrian scheme of vulnerable persons resettlement scheme, which ran from 2014 and was closed in 2021, which took about just over 20,000 people. We had a vulnerable children's resettlement scheme, which again closed in 2021, which settled about 3,000 children from the Middle East and North African region. There's a community sponsorship scheme, so individual communities can get together and agree to assist to sponsor a refugee, and I've had experience of that down in Devon. There is a UK resettlement scheme which has been announced to start, was announced to start last year, but was delayed, and it's, I think, unclear whether and how that is functioning at the moment. Then in the context of Afghanistan, there were schemes which assisted those who worked with the British in Afghanistan. This is pre-August of last year, when some other schemes were announced. Those earlier schemes were extremely restrictive, and I think almost nobody actually got relocated under those earlier schemes. And then, of course, when the Taliban took control of Afghanistan in August, there was an absolute need for assistance and an outcry here in the UK about wanting and needing to help Afghans. And so there were schemes created. One was a relocation and assistance policy for those predominantly who worked alongside the forces in Afghanistan. And then there was separately a citizens resettlement scheme, which prioritizes people who've assisted UK efforts in Afghanistan, but it's not clear how and whether it's functioning. There's no path for registering for the scheme. So these schemes are very limited. There are considerable delays in processing those who need relocation. The Syrian scheme took quite a long time to get going against a backdrop of a full-scale conflict. The Afghan schemes have been very limited. There are huge delays and huge problems in people applying, and there were lots of people who should have been or are eligible under the scheme who either have not yet had their claims processed, or even if they have had them processed, there is no obvious route for getting them to the UK. So they are problematic, and there's a very interesting report by two whistleblowers who worked under the Arab scheme and who gave evidence to a select committee about its failings and about the chaos and the lack of criteria and training at the time. So these schemes, I would say, are very problematic. And it was against this sort of backdrop that you had this bespoke, these bespoke Ukrainian schemes. So there are no existing legal routes for Ukrainians otherwise to reach the UK to claim protection. The government ministers suggested initially that seasonal worker routes and a standard visitor visa might be used, but those are obviously completely inappropriate for people who need longer term protection. And otherwise, Ukrainians would have to report or find people smugglers, and they may be prosecuted in the UK if they come without a visa. They're liable to detention on arrival. They would be ineligible to work, and they would be at the tail end of what Simon has already referred to as a very large backlog of asylum claims. Now, Yulia has made reference to the situation in Europe. The EU took a very different approach. So the 4th of March of this year, for the first time, the EU Council of Ministers adopted a decision under the Temporary Protection Directive, which allowed Ukrainian nationals and temporary residents the right to live and work and access healthcare, housing and education immediately in any of the 27 member states for up to a year without going through the asylum procedures. And that, of course, immediately allowed people to travel and under a sort of visa-free regime. So a huge contrast to the situation here. What happens if a Ukrainian? So what happens if a Ukrainian comes without a visa to the UK if they manage to get around the restrictions? I mean, first of all, they probably won't be able to board a flight or a ferry or get onto the Eurostar due to the 1999 Immigration and Asylum Act restrictions on carriers. They could have their application declared inadmissible because of a safe third country option. It'll be said that they could have claimed asylum in another EU state because they are inevitably likely to have come overland and come via Poland or one of the other EU countries. And they will face an enormous delay in considering applications. And of course, while those applications are being considered, they don't have the right to work. And they may also be liable to detention. In 2021, 24,000 people, over 24,000 people were entered into immigration detention. So what about the Nationality and Borders Bill? As the bill is proposed by the government, and of course it's been ping-ponged backs and forwards between the House of Lords and the House of Commons, but it will create a risk for a Ukrainian who has travelled through one of the other countries before getting to the UK. There is a risk that they may be pushed back if they crossed via the Channel. The Secretary of State contended that the existing powers allowed a pushback and has withdrawn that policy in relation to a challenge by freedom of torture, which was before the courts, and that has been withdrawn this week. But it remains to be seen whether the government's going to continue with the expanded provisions for pushback in the bill. A Ukrainian could be criminalised for the mere act of arriving in the UK and subject to a maximum of 4 years imprisonment. This would arguably fall foul of Article 31 of the Refugee Convention, which is the non-penalisation of refugees. They risk having their claim declared inadmissible. And again, the bill seeks to expand the existing provisions on admissibility, and again are contrary to the Refugee Convention. It's another way of using the concept of a first safe country against refugees. They also risk being removed to a remote state for offshore processing. Lord Etherton in the House of Lords has said this is wrong in principle, oppressive in practice, and critically lacking sufficient safeguards. And there are potential violations there under Articles 2, 3, 8 and 14 of the Convention of Human Rights, and under Articles 3, 31 and 33 of the Convention. Perhaps the most dangerous and pernicious element of the bill is this two-tier refugee status. And so under the government proposals, a Ukrainian refugee would risk being designated a Group 2 refugee and would be denied certain rights under the Refugee Convention, so that their leave ultimately could be limited, recourse to public funds might be limited, and family reunion rights might be limited. I mean, it's the view of a very large number of organisations and individuals, lawyers, former Supreme Court justices, that the bill is a flagrant violation of the UK's obligations under international refugee law, human rights law, and it's inconsistent with common law. If you're interested in this, there's a really excellent opinion published by the Good Law Project and written by 3 leading refugee lawyers, including one of my colleagues at Matrix. So it's do have a read of that. I think that's all I will say, and then we can open it up to questions.
Thank you very much. And thank you more generally to all of our fantastic panelists for their time, for your brilliant presentations. Thank you so much to the audience for your questions. We're really looking forward to our next event in the Ukraine series, which is going to be on the role of sanctions. The date is going to be fixed, likely to be end of June, beginning of July. It's going to be in person. There's going to be limited capacity, and Justice members are likely to receive priority booking to this event. We're just working through the details at the moment. As I said at the start, Justice is a small charity. We're often described as punching above our weight. I hope you agree this evening's event was not only insightful, but thought-provoking, and through our excellent speakers has hopefully raised your awareness of the issues involved, not just with Ukraine, but with wider refugees coming from across the globe. I hope to see you soon. Thank you again for joining us, and thank you once again to the panel, particularly in relation to your pro bono efforts over the last a few months. Thank you, everybody.